Honorable Justice Bhat delivered, as he himself called, comprehensive, comprehensible, very concise and rather profound talk, narrating his own experiences, and it's a source of inspiration for all of us. So now the floor is open for questions. Kindly make your questions short, straight and simple. So, and don't hesitate. As Honorable Justice Bhat said, courage is one of the most important quality of an effective lawyer. And of course, respect too. So, respectful courage. So with that, now, any question, anywhere? Yeah, please.
All India Judicial Service or a similar exam like that for the entry to High Court, because will solve the situation, because in situation like this they say that those who have links, they only go to the High Court and many others are left links. So do you think a similar exam will solve the situation in the expecting?
You have seen history happen. You have seen that one attempt was made by Parliament, they amended the Constitution, and the Supreme Court said in the NJSC judgment that that is contrary to basic structure. But then, as I said in the main part of, maybe I did not, society is dynamic. So what suits us today may not suit us tomorrow. We don't know what tomorrow holds for us. Well, as far as the privilege getting in or those with influence getting in is concerned, at least I hope that I and some of my colleagues are testimony to the fact that that is not correct. I did not have any legal background. I don't have any influence. And I can say that today, at least of many judges, that that's not correct. Yes, I'm sure in the coming years to come, many of you will grow up, you will talk about this, and there will be greater debates. As to what will happen, I can't say. But that's about all that I can comment, and I think I'll stick to that. Yeah. Yes.
So my question to you is, as you said that language is a vector of thoughts, but many times I found that the party didn't understand what the order said, because they didn't understand the English. In High Court also, or in the Supreme Court, many times counsel cheated the party, आपसे पेपर में है, ये अगली बार आना मैं इसको डिबेट करा दूँगा. But we never get the justice. Don't you think that the language is the barrier for the justice to
I think it's not an easy answer that I can give. Language can never be a barrier. What is a barrier is the gap between society as we know it and the people who practice the law. You see, there are many gaps in areas of law, especially in family law, maybe even in criminal law, where a proper advice by a lawyer can give a tremendous amount of solutions. Now, the assumption is that the lawyer knows it. Many times the lawyer does not. I can give you one example. For instance, in a criminal trial, at the end of the criminal trial, we have a procedure known as a Section 313 statement, where the judge sums up the entire evidence or whatever incriminating evidence is there and puts it to the accused. The accused, it's a conversation between the accused and the court, the only time in the trial. Now, at that point of time, the judge has to summarize the evidence against him accurately so that the accused understand. And secondly, the accused also has to answer convincingly. Frequently you see that sometimes a murder charge is there. The accused is advised to deny everything. Possibly if the accused is advised correctly, he gives his version when a murder charge could be converted to culpable homicide. So these gaps are there, and somehow this culture of not stating what is correct has come to stay. I think that is important for us. Yes. Low? Yeah. I can tell you there's a lot of difference between the kind of culture that you have in the US and what we have here. The US Supreme Court or even the circuit courts, which are the intervening appellate courts equivalent to our high courts, especially the Supreme Court, does not have a caseload like us. Dr. Suraj Singh told you they choose only 100 cases to decide. Usually the law clerks are, masters in law. They have done very brilliantly and they are picked up from law schools and asked to clerk. Now each judge typically has 4 law clerks and they work on drafts, which mean that they do intensive research on case law. And there's a lot of interaction between the offices of each judge, which means that a basic draft is prepared by one judge or his clerk, and there is a lot of to and fro negotiation between the kind of words that you wish to write in the judgment. So this whole myth that everything is written by law clerks is not correct. You look at the distinctive styles of, say, you mentioned Elena Kagan. Elena Kagan herself was a dean of Harvard Law School. John Roberts, also a brilliant litigator. Stephen Breyer, he was used to teach. Then he was, I think, a counsel for Congress, especially in securities matters. These are all highly accomplished people who used to write academically. Now, when they write, it is not their law clerks who are writing. The law clerks may have contributed to some initial part of the draft. And the second part is that in India, that kind of culture doesn't prevail. What I would typically do with my law clerk is to ask that boy or girl to work on a file, give me her or his summary of facts or law, depending on what I want, and then take it forward and see. Ultimately, the call is mine. If I write correctly, the judgment is upheld. If I don't do it right, it is my judgment, isn't it? So therefore, I cannot take the risk of someone else writing for me. And it's a myth again that American judges get their judgments written by the law clerks. That's not correct. Yes. Yeah, you're right. I personally feel that it should be there because the legal institutions, a law court is like a teaching institution. After all, it is telling society and the parliament and the government where it went wrong. So the role of the judges and the courts is not just to correct, but also to say what the law is, which means that you are telling the people that this is the law. So the process of that telling is also important. If you can come and attend the court physically, there's nothing wrong if it goes there on the net. The only debate can be that people should not be allowed to record it. There should be a method of recording it and putting it out there. You can actually see this video, live streaming, webcasting in the European Court and UK Supreme Court. It's all transparent. Every day, I think at 3 o'clock it starts. It's called Sky TV. So you can see there is an entire channel for the UK Supreme Court.
Sir, I have a question regarding the retirement age of judges. Sir, in 2015, I was visiting Justice Krishnan Memorial Lecture, sir. There, Justice Chandrachud raised this point that over a period of time, like 30 to 40 years, a lawyer gaining up experience becomes a judge over a period of time, and he is hardly provided with a window of 2 to 3 years, even sometimes only a couple of months to act, to be a judge, sir. And and then after that he's retired over a period of time. This is actually not a loss of the person, but of our judiciary as a whole, because one of the finest minds that are being sharpened over a period of 30 years are lost in one single person. So what are your views on this one point, sir?
Again, there can't be a yes or no. Yes, I agree that when I joined as a judge, I was just 45 years. Now I will be turning 59 next month. What do I see in 14 years? I'm not the same person. In the sense that the way I think, the way I express myself, the way I see life, and the experiences that I've undergone as a judge are of a far different quality. I would say they are much more superior. In my worldview, I am entirely different. Of course, physically also my molecules are different. I mean, everything has changed. So this process of refinement goes on. And I believe that in the later part of the 40s and 50s, when the judge is honing his skills, he starts excelling. But the biggest problem here is, and that's a debate, because we do need younger judges. We do need younger generation judges who think differently from us, who are more attuned to your generation. Not that we can't be attuned, but that there are closer to your generation who think like you, who are able to cope with the challenges that come up in the modern world. Again, I think some of the systems are more tested. In the US, he was mentioning about the US. In the US, your judges in the federal courts are appointed for life. But at the same time, there is an option for certain types of judges to step down after they've spent 12 years or 15 years and acquire what they call as senior status. So in senior status, you continue to get your salary, and you're expected to, vacate the seat, make way for a younger man or woman. And at the same time, you're not completely liberated. You still have to share 1/3 of the burden that you would have had to bear every year, which means that there is a nice mix of experience and youth, which, see, after all, when you grow older, maybe 65, maybe 70, depending on individual factors, your energy levels are not the same. If I can handle 70 or 80 cases today, there's no guarantee that I can handle 70 or 80 cases as efficiently 6 years later. That's a myth. Therefore, it is important to make way for younger people. If it's own, I don't want to say anything more. Our country is ruled by old people. It is high time that we start having a culture where younger people come forward. If Obamas and Kennedys and the likes can be in their 40s, why shouldn't judges also be in their youth in the Supreme Court, have a long tenure of what exists, rather than having them at the fag end of their career? In that sense, I don't entirely agree with you, but I do agree that there is a wealth of experience which has to be tapped.
But given the fact that longevity has extended, in 1947, 38, now it's 65, should the 70 at least, because now the people, even at the age of 70, are quite good mentally and physically. So instead of 65 as the retiring age, should we at least push it to 70?
I don't know what is the ideal, but I can only give you one point of view. One of my colleagues retired recently last year, and in a speech which he gave during the canteen, the lawyers' canteen usually provides a kind of a party, a send-off. He said, I'm very happy to provide relief to many lawyers here. So the point is, I'm sure there are plenty of lawyers and litigants who would like to see my back at the age of 62. So it's a controversial topic. It's a
There's another aspect to this which we generally academicians deal with respect to litigation. So we say maybe on a lighter note or what, that the judges from the higher division who never retire, their mode of service may change.
Correct.
Why? Because there are so many tribunals and all these mechanisms which have been created here. And the way those legislations are, the statutes are under which the tribunals are established, they take into consideration the age of a person will be
So and so.
on which a person from the High Court or the Supreme Court retires.